Hello Weirdlings, it's your friendly neighborhood lizard lady. This is part of the Staircase series and a standalone video, which means you can listen to this without having to listen to the rest of the series. Today we will be talking about the absolutely insane trial of Michael Peterson. Let's get into it. Dr. Lee, who I will discuss in next week's video, was brought on as an expert for Michael's defense. Lee testified that the blood spatter evidence was consistent with an accidental fall down the stairs. The police, on the other hand, concluded that the injuries were inconsistent with it being an accident. Because Michael was the only person in the home at the time of Kathleen's death, because the police believed she was murdered, Michael was their prime suspect. He was charged with murder and pled not guilty. Medical examiner Deborah Radish concluded that Kathleen had died from lacerations of the scalp caused by a homicidal assault. According to Radish, there were a total of 7 lacerations to the top and back of Kathleen's head. In Radish's opinion, the wounds were a result of repeated blows with a light yet rigid weapon. The defense, on the other hand, didn't agree. According to the defense, the lacerations were not consistent with blows of any kind. Why did they think that? Well, there was a lack of underlying injuries, no skull fractures, bruising, swelling, or hemorrhaging of the brain. That means, according to the defense, all of the injuries were on the surface. The trial became a media sensation. When Michael's sexuality emerged, it became part of the focus of the prosecution. The prosecution attacked Michael's credibility. They focused on him allegedly misreporting his military service and what they called a gay life he led and kept in secret. According to the prosecution, the Petersons' marriage was unhappy. They suggested that Kathleen had discovered Michael's alleged secret gay life and wanted to end the marriage. That was the main motive that they suggested. Also, a $1.5 million life insurance policy. According to Assistant District Attorney Frida Black, quote, Kathleen would have been infuriated by learning that her husband, who she truly loved, was bisexual and having an extramarital relationship, not with another woman, but a man, which would have been humiliating and embarrassing to her. We believe that once she learned this information, that an argument ensued and a homicide occurred. The defense, on the other hand, said that Kathleen accepted Michael's bisexuality and that their marriage was very happy. That was supported by Michael's and Kathleen's children and other friends and associates. Of course, the only people who fully know what the marriage was like were Michael and Kathleen. The prosecution believed that Kathleen's murder was most likely committed with a custom-made fireplace poker that was called a blowpoke. A blowpoke is a long 2-pronged fork-like thing used to poke the wood to add more air into the fire or to smother the flames with ash. Typically, a blowpoke can weigh 0.65 to 2.2 pounds, depending on the material used. The blowpoke in question had been a gift from Kathleen's sister, but was missing from the house according to the first sweep by investigators. The defense team later said that they found the blowpoke in the garage. I personally find that interesting. Usually, it's the defense team that doesn't want the suspected murder weapon found. After the trial, a juror was contacted. They said that the jury had dismissed the idea that the blowpoke was the murder weapon. Now, Kathleen wasn't the first woman in Michael's life that fell down a staircase. In 1985, in Germany, where Michael was stationed, a friend of his, Elizabeth Ratliff, was found dead at the foot of her staircase with injuries to the head. I discussed Elizabeth's death in the first part of this series. If you didn't watch that video, feel free to go back. But the TLDR is that Elizabeth Ratliff had an underlying bleeding disorder that prevented her blood from clotting. Her cause of death was determined by the local German police and the Air Force Military Police, together, to be caused by an underlying health condition, and either an aneurysm or stroke. Therefore, not murder. In April 2003, Ratliff's body was sent to Durham for a second autopsy performed by the same medical examiner who performed Kathleen's autopsy. The defense objected. Rightfully so. Why do I say that? Because I'm not saying the examiner was wrong, but they went into the autopsy knowing that Ratliff was connected to a man they already believed to have murdered another woman. That sounds like bias and tunnel vision to me. They weren't looking at it with a clean slate. They had the scissors out to make the puzzle pieces fit, and then force them into place. Allegedly. The Durham medical examiner found sufficient evidence in their words, along with new witness statements, 20 years later, describing the scene and overturned the previous cause of death, stating it as a homicide. Now, let's pause again. After being embalmed, the signs of bleeding on the brain are gone. Any bruises, especially after 20 years, are gone. The only things that could have still been there are broken bones. But if any were found and not noted in the first autopsy, well, she was flown in the cargo area of a plane from Germany to Texas. Let all of that sink in, weirdlings. The prosecution declined to accuse Michael of Ratliff's death, but they still used it in the trial, saying that it gave Michael the idea of how to, in their words, fake Kathleen's accident. The nanny, who was the first person to discover Ratliff's body, took the stand in Michael's trial and said there was a lot of blood at the scene. Another woman testified to spending a long stretch of time that day cleaning blood stains off the wall. Yet, the original police report did not mention large amounts of blood. Now, I'm not saying they were lying, but it was over a decade later. Eyewitness testimonies normally aren't used as the sole piece of evidence for a reason. Memory is fallible. You don't remember a memory as it happened. You remember the last time that you remembered the event. In the previous video, I go into the ship of Theseus, which is a philosophical problem. It is just a way to visualize how, over time, memory can change. Michael's attorneys were able to use the eyewitness testimony from the Ratliff death in their appeal in 2005, in their attempt to have the prosecution overturned. In October 2002, Caitlin, Kathleen's daughter, acting as the administrator of Kathleen's estate, filed a wrongful death claim against Michael. In June 2006, Michael filed for bankruptcy. 2 weeks later, Caitlin filed an objection to the bankruptcy. On February 1st, 2007, Caitlin and Michael settled the wrongful death claim for $25 million, as long as the courts accepted. On February 1st, 2008, the settlement was finalized. On October 10th, 2003, the trial was one of the longest in North Carolina history. A Durham County jury found Michael Peterson guilty of Kathleen's murder. He was sentenced to life in prison without the possibility of parole. Denying parole means that the murder was premeditated. Now, the jury accepted that the murder was a spur-of-the-moment crime, but also premeditated. That might seem a little odd, but technically, you only need a few seconds to be considered premeditated. Think about it this way. You and a friend are out at a bar. Someone approaches and starts a fight. The initial fight between you two is not premeditated, and could even be considered self-defense. However, if you take a step back, take a breather, out of the fight, no immediate danger, you could walk away. But if you turn back around, choose to strike again, the next strike is premeditated. That's not just some example I came up with. In fact, something similar happened in Ruby Creek. Okay, fine. The town I based Ruby Creek on, if you want to get technical. A group of friends were leaving a bar. There was an altercation between that group and another that they had an association with. A fight broke out, was broken up, and everyone was supposed to walk away. One of the people from the first group went to his car and got his legally owned and legally open carried, this is Nevada, gun out of his car and opened fire. He was charged with premeditated assault with a deadly weapon. Because he had a chance to leave the scene, yet he chose to escalate. With that in mind, we can deduce that the jury believed that Michael took the opportunity of Kathleen being intoxicated to attack, incapacitate, and murder her with a blowpoke. The act of reaching for the blowpoke is where it becomes premeditated, because it was not within arm's reach of the attack location. Well, the location according to the prosecution. Michael was housed at the Nash Correctional Institution near Rocky Mount until December 16, 2011. That's not life, so our story isn't over yet. On April 18, 2006, Thomas Mayer, Michael's newly court-appointed attorney, filed for an appeal before the North Carolina Court of Appeals. On September 19th, the Court of Appeals rejected Michael's arguments that he didn't get a fair trial because of repeated judicial mistakes. I mean, in my opinion, Ratliff's autopsy, nearly 2 decades later, conducted by the same person that already believed that he was a murderer, is grounds for appeal. The Court of Appeals, of course, said that the evidence was fairly admitted. Sure, Jam. The prosecution also villainized Michael's bisexuality. That seems totally fair too, right? Side-eye. The judges did find defects in a search warrant, but said they had no ill effect on the defense. And you wonder why people don't trust law enforcement. And Michael was an affluent, white, cis, male veteran. Seems like he would get the best treatment in court. Now, the ruling was not unanimous. Under North Carolina law, Michael had the right to appeal to the North Carolina Supreme Court. They accepted the case, hearing an oral argument on September 10th, 2007. On November 9th, 2007, the court announced that it agreed with the Court of Appeals. Without new evidence or a new federal ruling, Michael was out of choices. Legally, he was stuck. On November 12th, 2008, attorneys J. Burkett Beale and Jason Anthony from Richmond, Virginia, were now representing Michael. They filed for a new trial in Durham County on 3 grounds. That the prosecution withheld exculpatory evidence. Real quick, let's talk about what exculpatory evidence is. In layman's terms, easy to understand English, not fancy Latin, is basically get out of jail evidence. Anything that shows that the defendant didn't commit the crime, or that points to their innocence. The opposite would be inculpatory evidence, which basically suggests guilt. Some examples: an alibi, witness saying you were somewhere else, DNA that doesn't match the defendant, security footage showing someone else doing the crime, or a confession from another suspect. So, in U.S. law, prosecutors are required to share exculpatory evidence with the defense. This is known as the Brady Rule, which comes from the Supreme Court case Brady v. Maryland, 1963, not to be confused with the Brady Bill, 1993. The Brady Rule states that if they hide evidence, that's a huge violation. The Brady Bill was named after James Brady, who was the White House press secretary who was shot and severely injured during the 1981 Reagan assassination attempt. This law established federal background checks for gun purchases. So a way to remember: Brady Rule is for fair trials, Brady Bill is for gun control. 2 Bradys, 2 very different laws. And meanwhile, I live in Nevada, where they'll card me harder for a slot machine margarita than for a gun. And oh yeah, there are 3 legal brothels in my town. The Wild West is alive and well, folks. Nevada is bananas. The Domino's in town is literally inside a gas station. It used to have slot machines too, until COVID shut that down. So yeah, background checks? Nah. Gas station pizza and slots? Absolutely! So, the missing exculpatory evidence that was withheld, according to the new defense, was about the blowpoke. The prosecution used an expert witness whose qualifications were disputed, and one of the jurors based his judgment on racial factors. So much for being impartial. On March 10, 2009, Michael's motion for a retrial was denied by the Durham County Superior Court, but all hope wasn't lost for Michael. In August 2010, a series of newspaper articles critical of the SBI, the State Bureau of Investigation, North Carolina's version of the FBI, Federal Bureau of Investigation, North Carolina Attorney General Roy Cooper led an investigation that then resulted in SBI analyst Dwayne Deaver being suspended. Deaver was one of the principal witnesses against Michael. Dwayne Deaver was the blood spatter expert for the prosecution. Evidence showed that he misrepresented evidence and was unreliable. T. Lawrence Pollard, a neighbor of Michael and Kathleen, and a Durham County attorney, filed affidavits to support a motion that Superior Court Judge Orlando Hudson ordered that the State Medical Examiner's Office turn over all documentation related to Kathleen's death to Michael's attorneys. Pollard believed that not all of Michael's attorneys received the full autopsy report, which is a violation of the Brady Rule, which we discussed earlier. That includes notes, photographs, lab results, and any material that might be favorable to the defendant. Now, Michael's attorneys did receive autopsy material, but one of the controversies in the case was just how complete and accurate the information they received was. Pollard also had questions about expert witnesses, like Deaver, and whether certain evidence like injury specifics, alcohol levels, or subtle markings was adequately shared or emphasized. Because Michael had multiple attorneys over the years, each attorney must have access to all of the evidence. If any attorney didn't have access to all of the evidence, they can't properly defend him. However, Judge Hudson barred Pollard from filing any further motions on behalf of Michael because Pollard was not Michael's attorney. In August 2010, David Rudolph, one of Michael's original attorneys, filed a motion pro bono, which basically means for free, to challenge the testimony of the SBI. In January 2011, Dwayne Deaver was fired from the SBI after an independent agency found that he had falsely represented evidence in 34 cases, which included negative results in the case of Greg Taylor, a North Carolina man who spent 17 years in prison on a murder conviction based on Deaver's testimony. A bloodstain analysis team which Deaver had trained was suspended and disbanded. In Michael's 2003 trial, Deaver testified that he had been mentored by SBI bloodstain specialist David Spittle and had worked on 500 bloodstain cases, written 200 reports, and had testified in 60 cases. If that were true, then it would have been very impressive. However, during the retrial hearing, SBI Assistant Director Eric Hooks testified that Deaver had only written 47 reports. That's still a lot, but not the number he had stated before. However, during the retrial hearing, SBI Assistant Director Eric Hooks testified that Deaver had only written 47 reports. That's still a lot, but not the number he had stated before. The specialist, David Spittle, testified that he could not remember mentoring Deaver, who, after completing a 2-day training course in the 1980s, had only testified in 4 cases. Michael's case was his third. The SBI pointed to the bloodstain analysis given in the 4th case as the reason for Deaver being fired. On December 16, 2011, Michael was released from the Durham County Jail on a $300,000 bail and placed on house arrest with an ankle monitor. His release was after a judicial order for a new trial after Judge Hudson found that Dwayne Deaver had given, quote, materially misleading and, quote, deliberately false testimony about bloodstain evidence, exaggerated his training, experience, and expertise. Dwayne Deaver basically pulled a Senor Chang, lied about knowing Spanish, he learned it from Sesame Street, and didn't have a teaching degree. Former North Carolina Attorney General Rufus T. Edmiston said that any evidence gathered after Deaver arrived at the scene might not be allowed in a new trial. In July 2014, Michael's bond restrictions were eased. In October 2014, the court appointed Mike Klinkenstone to represent Michael. Can I just say there are so many effing attorneys in this case? David Rudolph, who had been representing Michael pro bono since his conviction was overturned, said that he could no longer afford to represent Michael without being paid, which is fair. On November 14, 2016, Michael's request for the second trial to be dismissed was refused, and a new trial was scheduled to begin on May 8, 2017. However, a news report on February 7, 2017, stated that a resolution had been negotiated by Rudolph, who was representing Michael again, and the Durham County District Attorney. On February 24, 2017, Michael entered an Alford plea to the voluntary manslaughter of Kathleen. I'll explain what an Alford plea is in a future video. The judge sentenced Michael to a maximum of 86 months, 7 years, 2 months in prison with credit for time served. Because Michael had already served 98.5 months, 8 years, 2.5 months, he was a free man. He didn't have to serve any more time. When a defendant accepts an Alford plea, basically, a defendant is saying, I'm innocent, but I'll plead guilty because the evidence is strong enough that I'd probably get convicted anyway. Sleep well, Wehrlings, and I really hope you don't have to deal with the legal system. It's effing bananas.